For the second year in a row, Drake takes another massive L. But let's understand exactly what the hell just happened. I'm going to 100% convince you that what the courts actually did was right, even if you're a Drake fan. I'm not going to interject in any parts of the reading, so you're just going to hear the whole entire thing. But if you don't and you want me to surmise and summarize it up, just skip all the reading in about 30 minutes at the 30-minute mark, and we'll go ahead and break it all down for you. Let's go. Now, y'all know the hood lawyer couldn't wait to get his hands on this one. Let's go ahead, opinion in order. This case arises from perhaps the most infamous rap battle in the genre's history, the vitriolic war of words that erupted between superstar recording artist Aubrey Drake Graham and basically Kendrick Lamar. Over the course of 16 days, the two artists released 8 so-called diss tracks with increasingly heated rhetoric, loaded accusations, and violent imagery. The penultimate song of this feud, Not Like Us by Kendrick Lamar, dealt a metaphorical killing blow, which means the judge is saying, hey, you lost due to this song, according to Drake as well. The song contains lyrics explicitly accusing Drake of being a PDF set to a catchy beat and propulsive bass line. Not Like Us went on to become a cultural sensation, achieving immense commercial success and critical acclaim. Both Drake and Kendrick Lamar have recording contracts with defendant UMG Records. Drake alleges that UMG intentionally published and promoted Not Like Us while knowing the song's insinuations that he has X relations with minors were false and defamatory. A minor. Drake has brought this action against UMG for defamation, harassment in the second degree, and violation of Section 349 of the New York General Business Law before the court is defendant's motion to dismiss pursuant to Rule 12b-6 of the Federal Rules of Civil Procedure, because the court concludes that the alleged defamatory statements in Not Like Us are non-actionable opinion. The motion to dismiss is granted. Drop the lawsuit. Legal standards. To survive a motion to dismiss, the complainant must contain sufficient factual matter accepted as true to state a claim to relief that is plausible on its face. Kaplan versus Lebanese Canadian Bank, SAL. A plaintiff must not simply allege facts that are consistent with liability. The complaint must nudge plaintiff's claims across the line from conceivable to plausible. Threadbare recitals of the elements of cause of action supported by mere conclusory statements do not suffice. When ruling on a motion to dismiss under Rule 12b-6, the court accepts as true all well-pleaded allegations and draws all reasonable inferences in favor of the non-moving party. The court need not credit legal conclusions couched as factual allegations. However, Dixon versus Von Blackadese, I don't know how to say that, but whatever. The court may also consider documents incorporated in the complaint by reference and matters of which judicial notice may be taken. Judicial notice is appropriate when a matter is not subject to reasonable dispute because it is generally known within the trial court's territorial jurisdiction or it can be accurately, readily determined from sources whose accuracy cannot reasonably be questioned. Background. The following background is largely taken from allegations in the amended complaint, which are assumed true purposes of this motion. Additionally, defendant requests the court take judicial notice of certain extrinsic evidence pursuant to Rule 201 of Federal Rules of Evidence. These exhibits include the lyrics of the songs released as part of Drake and Kendrick Lamar's rap battle, the dates on which these songs were released, and the lyrics of these songs are not reasonably subject to dispute. And the songs themselves are, with one exception, all referenced in the amended complaint. Accordingly, the court will take judicial notice of Exhibits H through I and Exhibits K through O to the request for judicial notice to understand defendant's alleged statements in their necessary and proper context. Taking judicial notice of submissions that place the defendant's comments in the broader social context to aid the court's determination of the adequacy of plaintiff's defamation claims. Exhibits B, J, and P are directly referenced and relied upon in plaintiff's amended complaint. J, not 1 through 4, so those documents are likewise properly before the court. And because the document can be accurately, readily determined for sources whose accuracy cannot reasonably be questioned, court also takes judicial notice of the search results of the New York Times website in Exhibit C. The court takes judicial notice of the existence. Man, we ain't doing all that, bruh. Come on, let's just get to it. Factual allegations. Drake is a prominent recording artist and songwriter, among other public-facing endeavors. Drake has had a successful music career under defendant UMG for at least 20 years. UMG uses its brands and imprints or labels to provide its music artists with the means to create, promote, and distribute their music. Commercially defended through Universal Music Publishing Group, holds exclusive publishing and distribution rights to Drake's music, as well as that of artist Kendrick Lamar. On April 19, 2024, Drake released a diss track directed at Kendrick Lamar called Push-Ups. Drake mocks Lamar's height and shoe size. How the F you big stepping with a size 7 men's on, pimp squeak, pipe down, and question Lamar's success. You ain't in a big three, I'm at the top of the mountain, so you tight now. Just to have this talk to you, I had to hike down. A few days later, Drake released Tailor Made Freestyle, in which he used artificial intelligence generated voices of deceased rapper Tupac and of rapper Snoop Dogg to goad Lamar. In the track, Tupac and Snoop Dogg share their disappointment that Lamar has not yet responded to push-ups. Kendrick, we need you, the West Coast savior. You seem a little nervous about all the publicity. You got to show this effing Al who's the boss on the West. Drake, in his own voice, further taunts Kendrick for failing to come up with a satisfactory response, saying, I know you in that NY apartment, you struggling right now. I know it. In the notepad doing lyrical gymnastics, my boy. Drake also surmises that Kendrick was purposefully delaying his response because artist Taylor Swift had just released an album. Shout out to Taylor Swift, biggest gangster in the music game right now. She got the whole PG Lang on mute like that Beyonce challenge. Y'all boys quiet for the weekend. Lamar fired back at Drake in Euphoria, which was released on April 30th, 2024. In the track, Lamar claims, I make music that electrify him. You make music that pacify him. And that he would spare Drake this time that random act of kindness. He accuses Drake of fabricating his claims. No, you a master manipulator and habitual liar too. But don't tell no lie about me, and I won't tell truth about you. Shoo, beep. Let me stop. He insults Drake's fashion sense. I hate the way that you walk. I hate the way that you talk. I hate the way that you dress. Further raps, I believe you don't like women. It's a real competition. You might pop ass with him. And taunts Drake for being a coward with his response. I hate the way that you sneak this. If I catch flight, it's going to be direct. On May 3rd, 2024, the feud between Drake and Lamar escalated as they lobbed increasingly vicious personal accusations at each other over the course of the day. First, Lamar released 616 in LA, in which he calls Drake a terrible person. Lamar accuses Drake of playing dirty with propaganda and raps that if Drake was street smart, then he would have caught on that his entourage is only there to hustle him. Drake's next response arrived later that day in Family Matters. Drake jabs at Lamar's relationship with his partner. You the black messiah wifing up a mixed queen and hit vanilla cream to help out with your self-esteem on some Bobby stuff. I want to know what Whitney need. He implies that Lamar physically abused her. You a dog and you know it. You just play sweet. Your baby mama captions always screaming, save me. You did her dirty all your life. You trying to make peace. I ain't gonna lie. Drake was on Cuz Hill with them bars, though. I still rock with Drake. I don't care what happens. Moreover, Drake calls into question whether Lamar is the biological father of his children. I heard that one of them little kids might be Dave Free. Don't make it Dave Freeze. Almost immediately after the release of Family Matters, Lamar unleashed a scathing Meet the Grams, in which he accuses Drake of being a deadbeat father and hiding the existence of other children. You lied about your son, you lied about your daughter, you lied about them other kids that's out there hoping that you come home. Lamar also alleges that Drake has gambling problems, drinking problems, pill popping, and spending problems. Bad with money, whore's house, soliciting women's problems. Therapy's a lovely start. He further insinuates that Drake was a predator and that Drake should go away so all these women can live with a purpose. I can't say that word just yet because we only 9 minutes in. The next day, on May 4th, 2024, Lamar released Not Like Us. Not Like Us explicitly names Drake and his associates as PDFs. Specifically, the track contains the following lyrics. Say, Drake, I hear you like me young. You better not ever go to Cell Block 1. To Winnie B that talk to him and they in love, just make sure you hide your little sisters from them. They tell me Chubb's the only one who get your hand-me-downs and party at the party playing with his nose now. And Baka got a weird case. Why is he around? Certified lover boy, certified. Wop. Not F him up. Wop. I'ma do my stuff. Why you trolling like a, ain't you tired? Try to strike a chord and it's probably A minor. On May 5th, 2025, Drake responded in The Heart Part 6 at directly denying Lamar's allegations of PDF. I never been with no one underage, but now I understand why this angle is what you really mess with. Just for clarity, I feel disgusted to respect it. If I was to F with young girls, I promise I've been arrested. I'm way too famous for this stuff you suggested. Drake is not a name that you gonna see on no ex-offender list. In the track, Drake further sneers that this Epstein angle was the stuff I expected and accused Lamar of wanting to misdirect. Drake also alleges that he had planted some of the information Lamar has used against him. We plotted for a week and fed you the information, but you so thirsty you're not concerned with the investigation. You got to learn to fact check things and being less impatient. Not Like Us was a huge commercial success. It has gained immense popularity on streaming and social media platforms. It has been streamed globally more than 1.4 billion times on Spotify alone as of April 2025. On November 8, 2024, the Recording Academy nominated Not Like Us for several Grammy Awards, and in February 2025, it won Record of the Year. A week later, on February 9, 2025, Kendrick Lamar performed Not Like Us during the Apple Music Super Bowl halftime show. The performance is alleged to be the most watched Super Bowl halftime show of all time, with over 133.5 million views. Procedural history. Plaintiff begins claims for defamation, harassment in the second degree. You gotta be kidding me. For real? In violation of New York General Business Law, Section 349, based upon UMG's publication and promotion of Not Like Us, defendant has filed a motion to dismiss the amended complaint. June 30th, 2025, the court heard oral argument from both parties concerning the motion to dismiss and the request for judicial notice. Plaintiff contends that he was defamed when defendant decided to publish, promote, exploit, and monetize allegations that it understood were not only false but dangerous. Recording repeatedly accused Drake of engaging in criminal acts, including PDF and or other acts that would require registering as an ex-offender and being registered as an ex-offender. The amended complaint alleges that the song implies that Lamar is heard, albeit from undisclosed sources, and concerning undisclosed sources, that Drake has a predilection for underage women. According to the amended complaint, the references to Cell Block 1 is a thinly veiled threat that Drake should be careful that he never ends up in prison, a place where child predators are notoriously the targets of violence. The line, certified lover boy, certified PDF, is a perverse reference to Drake's 202 album cover, Certified Lover Boy. Plaintiff argues that the use of the term certified communicates that Drake has been found to be a PDF, and the final line of the passage plays on the dual meaning of minor, a person under the age of 18, and a musical scale. Plaintiff further cites as defamatory the recordings descriptions of Drake as Malibu's most wanted and a predator, and his name got to be registered and placed on Neighborhood Watch. The associated music video shows images associated with ex-trafficking to reinforce the PDF accusation. The recording is also accompanied by an album image of Drake's home in Toronto, the image which is plastered in icons by law enforcement and public safety applications to denote the residence's registered ex-offenders. I'm sorry. Under New York law, the elements of defamation claim a defamatory statement, fact 2, regarding the plaintiff published to a third party that is false, made with applicable level of fault, causing injury, and not protected by privilege. A defamatory statement is one that exposes an individual to public hatred, shame, obliquely, I don't know how to say that. Obloquy? I don't know. Contumely, odium, contempt, ridicule, aversion, ostracism, degradation, or disgrace, or induces an evil opinion of one in the minds of right-thinking persons and deprives one of confidence and friendly intercourse in society. The issue in this case is whether Not Like Us can reasonably be understood to convey as a factual matter that Drake is a PDF or that he has engaged in X relations with a minor or with minors. In light of the overall context in which the statements in the recording were made, the court holds it cannot. Fact versus opinion. This ought to be good. Under the First Amendment, there is no such thing as a false idea. What? Wow, the court must distinguish between statements of fact, which may be defamatory, and expressions of opinion, which are not defamatory, and have the full protection of New York Constitution. Whether a challenge statement in fact or opinion is a legal question. Plaintiff argues that it is inappropriate for the court to determine at the pleading stage whether a reasonable listener would perceive that the recording as fact or opinion. Yet, because this is a question of law, New York courts routinely resolve this question at the motion to dismiss stage. Wow. Opinion is a question of law for the courts to be decided based on the average person hearing or reading communication would take it to mean. And this is appropriately raised at the motion to dismiss, holding that because whether the statement is defamatory presents a legal issue to be resolved by court, defamation actions are particularly suitable for resolution on a motion to dismiss. There is a particular value in resolving defamation claims at the pleading stage so as to not protect litigation through discovery and trial, thereby chill the exercise of constitutionality protected freedoms. And distinguishing between facts and opinions, 3 factors, man, we don't care about none of that crap, bro. Just start the courtroom. We don't care about that. We don't care about that. The decision in New York, we don't care about that crap. Basically what they're doing is they're making sure that when Drake appeals, that they're very thorough in the laws in which they are using. That's what this is basically for. Like all of that crap that you're seeing, all of that crap that you're seeing, right? You know what I mean? Basically, that's what you're seeing. So, for example, in Euphoria, Lamar calls Drake a master manipulator, a habitual liar, and a scam artist. Drake responds in Family Matters by heavily implying that Lamar is a domestic abuser. He also raps that he heard that one of Lamar's sons may not biologically be his. Why you never hold your son and tell him, say cheese? You could have left the kids out of this, don't blame me. I heard that one of them little kids might be Dave Freeze. And Meet the Grams, Lamar takes issue with Drake involving his family members in their feud. Dear Aubrey, I know you're probably thinking I wanted to crash your party, but truthfully, I don't have a hating bone in my body. This is supposed to be a good exhibition within the game, but you effed up the moment you called out my family's name. Why you had to stoop so low to discredit some decent people? In the same track, Lamar alleges that Drake uses the weight loss drug Ozempic. Don't cut them corners like your daddy did. F what Ozempic did. Don't pay to play with them Brazilians. Get in a gym membership. Lamar also insinuates that Drake knowingly hires ex-offenders. Drake grew facial hair because he understood being a beard just fit him better. He got ex-offenders on Hovio, that he keeps on a monthly allowance. Of particular relevance and tailor-made freestyle, Drake challenged Lamar to make the PDF accusations at issue, which we all said. Using the artificially generated voice of the deceased rapper Tupac, Drake goads Lamar. Kendrick, we need you, the West Coast savior, engraving your name in some hip-hop history. If you deal with this viciously, you seem a little nervous about all the publicity. F this Canadian light-skinned die. We need no debated West Coast victory, man. Call him a B for me. Talk to him about liking young girls. That's a gift for me. Heard it to be on the Budding podcast. It gotta be true. It is in this context in which such lyrics say, Drake, I hear you like him young, from the recording must be assessed. The similarity in the wording suggests strongly that the line is a direct callback to Drake's lyrics in the prior song. So basically, Drake, you wouldn't have even been called this had you not said it first. Plaintiff argues that the court should ignore the song that came before and assess Not Like Us as a singular entity. Plaintiff argues that the average listener is not someone who is familiar with every track released as part of the rap battle before listening to the recording, because the recording has achieved a level of cultural ubiquity. I don't know how the hell I just messed that up. Ubiquity far beyond other 7 songs. Plaintiff contends that courts should not consider those other tracks in assessing how the average listener of the recording would perceive the allegations regarding Drake. There are a number of flaws in this argument. Not Like Us cannot be viewed in isolation, but must be placed in its appropriate factual context. Statements must be viewed in their context in order for courts to determine whether a reasonable person would view them as expressing or implying any facts. Here, the factual context is the insults and trash talking that took place via these diss tracks and the days and weeks leading up to the publication of Not Like Us. The songs released during this rap battle are in dialogue with another. They reference prior songs and respond to insults and accusations made by the rival artist. The song thus must be read together, fully assesses how the general audience would perceive the statements in the recording. Notably, the Second Circuit rejected a similar argument, blah, blah, blah. Moreover, the plaintiff is correct that the intended audience for the recording is the general public and not a subset for rap devotes or Kendrick Lamar fans. The recordings in the rap battle were likewise released to the general public. These were not songs accessible to a select niche, but tracks released by commercially successful artists. While Not Like Us may be the most popular of the diss tracks, the other songs were hits in their own rights, with streams in the tens of millions or hundreds of millions. Additionally, it was not just the recordings which gained cultural ubiquity, but the rap battle itself. In deciding this motion to dismiss, the court need not blind itself to the public attention garnered by this particular rap battle. The court takes judicial notice of extensive mainstream media reporting that surrounded the Not Like Us and associated feud between Drake and Kendrick Lamar rap battle to assess whether the average listener would take Lamar's statement as objective fact or opinion. Perhaps most fatally for plaintiff's argument, it would render protection for artistic expression dependent upon the impermissible retroactive analysis. At the time he released Not Like Us, Kendrick Lamar could not have been aware that it would break streaming records, win Record of the Year at the Grammys, or be featured at the Super Bowl halftime show. Yet plaintiff would have had the court divorce the recording from context in which it was created because of these subsequent events. Whether publications constitute actionable fact or protected opinion cannot vary based upon the popularity they achieve. Constitution, no guarantees do not rest on such flimsy foundation. Plaintiff counters that even if the recording was protected opinion at the time of its initial publication, UMG's publication of Not Like Us in the months following after it achieved unprecedented levels of commercial success exposes it to liability. The argument is logically incoherent. If the recording was non-actionable opinion at the time it was initially produced, then its republication would not expose UMG to liability. Replication cannot be transformed into Lamar's statement of opinion into UMG's statement of facts. Tone and language. That the recording can reasonably be understood as opinion is reinforced by the language employed by the song. There's a whole bunch of crap that we don't need to read. Not Like Us is replete with profanity, trash talk, and threats of violence in figurative and hyperbolic language, all of which are indicia of opinion. A reasonable listener would not equate a song that contains lyrics such as "Ain't no law, boy, you a ball boy, fetch Gatorade or something. Since 2009, I had this bitch jumping," with accurate factual reporting. According to reasonable listeners, Not Like Us would conclude that Lamar is rapping hyperbolic. Plaintiff contends that in determining if the lyrics Not Like Us express fact or opinion, the court must consider the subjective views of its listeners, as well as commentators in the rap industry and press who understood the recording video and image as an attempt to convey a precise factual message. The amended complaint cites extensively to comments and posts from YouTube and Instagram that express the belief that the recording had exposed the truth and that Drake truly was engaged in pedophilia and sexual violence against children. But distinguishing between fact and opinion is a question of law for the courts to be decided based on what the average person hearing or reading the communication would take it to mean. Let's go down. The courts hold, based upon the full consideration of context in which Not Like Us was published, that a reasonable listener could not have concluded that Not Like Us was conveying objective facts about Drake. The views expressed by users, whoever, they talking about Kai and a whole bunch of other cats, and the other YouTubers, Instagrammers, commentators quoted in the complaint, do not alter the court's analysis. In a world in which billions of people are active online support for almost any proposition, no matter how far-fetched, fantastical, or unreasonable, can be found with little effort in any number of comment sections, chat rooms, and servers. That some readers may infer a defamatory meaning from a statement does not necessarily render the inference reasonable under circumstances. Basically said, Drake, if your ass come out and say somebody's opinion is paid for, you gonna have to prove that. Other than that, everybody has an opinion about everything in anywhere. It don't matter what the hell is said. Mixed opinion, we don't really care about none of that. Let's go down. We don't care. Second degree harassment. New York does not recognize a civil cause for action for harassment. Nigga, you said you got harassed. Notwithstanding, the precedent, plaintiff attempts to bring a claim for harassment under section 240.263 of New York Penal Code. A person commits harassment in the second degree when they hold the intent to harass, annoy, or alarm another person and engage in a course of conduct or repeatedly commit acts which alarm or seriously annoy such other person and which serve no legitimate purpose. Individually and collectively provide a call to target Drake, including through violence and defendant's course of conduct, publishing specific and unequivocal threats of violence have placed plaintiff in unreasonable fear or physical harm. This state of criminal statute does not provide a private right of action. However, accordingly, plaintiff fails to state a claim for harassment. Basically, you just saying you being harassed. Where's the damn proof? Under New York law, where penal statute does not expressly confer a private right of action on an individual pursuing civil relief, recovery under such a statute may be had only if a private right of action may fairly be implied. Let's keep on going down. What news you got today? You want me to stop reading to address you? Okay, all right. Because you can't read. It says Drake's lawsuit, right? Okay, cool. The court disagrees to allege that UMG implemented covert practices to manipulate streams for Not Like Us and inflate the recording's perceived popularity. Plaintiff relies on tweets by individual users and reporting from fans to allege that UMG utilized covert tactics to manipulate streams Not Like Us. The court finds plaintiffs reliance on online comments and reporting insufficient to meet the plausibility standard. Basically, you didn't even have proof. All you did was use people's opinions on what the hell just happened. While these covert practices of providing financial incentives to undisclosed third parties and leveraging of business relationships, if they exist, may be facts that are peculiar within the possession of control of UMG's plaintiff's allegations, based on what boils down to unreliable online commentary, do not form a sufficient factual basis such that there is a reasonable expectation that discovery will reveal evidence of illegality. Basically, Drake, you didn't even have proof of none of this stuff that you just alleged. Even if the court accepted plaintiff's pleadings on information and belief, plaintiff still has not stated a claim for relief. Wow. Plaintiff has not sufficiently alleged deceptive practices that are consumer-oriented. Under New York law, the term consumer is consistently associated with an individual or natural person who purchases goods, services, or property primarily for personal, family, or household purposes. A defendant engages in consumer-oriented activity if the company's actions cause any consumer injury or harm to the public interest. While Section 349 does not preclude any action brought by one business competitor against another, it is at its core a consumer protection device. The amended complaint does not indicate how any of the deceptive practices alleged utilize UMG harm consumers. Wow. That's crazy. For example, the amended complaint does not allege that consumers paid more than they otherwise would have for a product purchase, a product that they likewise would not have become of misrepresentations regarding the product, or likewise received less than value for any purchase. Basically, Drake, you screwed yourself. Defendant's motion to dismiss is granted. The clerk of the court is respectfully directed to terminate ECS NOS 4278 and 81 and to close the case. So order dated October 9th, New York, New York. So the court is saying basically this: even if they botted the views and all this crap and everything, you couldn't have predicted what the song was going to do commercially, meaning the Super Bowls, the Grammys, and all of this crap, the cultural impact and all that. With him saying basically they wouldn't even, this is Drake's argument, they wouldn't even had this had they not inflated it. The court is saying even if they inflated it, bro, it doesn't matter. It doesn't deter from what actually happened. So Drake, you messed yourself up. At the end of the day, Drake's lawsuit came because he lost and he's a sore loser. All right, cool. You got the money to fight it your way? Fight it your way. But this loss right here, it screws Drake so many times over because they wrote it so long to show Drake. You said in the tailor-made freestyle, say that he messed with kids. They didn't even mention the fact, well, they did. They mentioned the fact that you basically said, hey, I already knew this stuff. And you said out your own damn mouth that you planted the evidence for Kendrick Lamar to use. That means no matter what the hell you say, you did this to yourself. Whoever gave you the advice to sue him, bruh, they ruined it. What Drake should have did, and this is my opinion, this is 100% my opinion, when I was going on live streams, I would see weird ass people coming into my Instagram and basically saying little here's and there's. And I can't prove that any of these cats were Drake's supporters, was Drake directly or Kendrick Lamar directly. But the day before, not like us dropped, when Kendrick dropped that, when Drake dropped that damn, that song, that I'm like, this hard. But it's not the killing blow. And what I said was Drake needs to go in there and write to a West Coast beat, a Draco type something, Mac Drake type something, E40 type something, YG type something that the West is going to be forced to play, that the streets is going to play. That's where you're going to win this battle at. But I also said, hey, Kendrick needs to come out with a song immediately that people can shout back at Drake in clubs and strip clubs and all this crap. He needs a saying. He needs a chant. And lo and behold, Not Like Us was born no less than god dang 14 hours after I said that. Why is that important? Because smart people, it ain't just me, knew exactly what needed to happen. The moment that you address something, and this is the Machiavellian thing that people forget, the moment you address allegations is the moment that you lost, even if you're 100% right. What Drake basically did was you forced the damn judge to say you lost. which means we're now all about to go back and listen to that damn song. I know I am. I'm about to go get my car washed, but one thing I'm about to do is turn on They Not Like Us. They Not Like Us. Why? Because Drake, the rap culture is petty. Maybe you forgot this part because in all of your winning, when the petty was happening for you and not to you, you missed the mark. Remember, back to back. That's all they were saying. Is that a world tour or your girls tour? You had the formula. You knew the formula and you rejected the formula. It's your fault, Drake, and you need to do exactly what I said. You should have, as soon as Not Like Us came out, you should have came out and said, song is catchy, but it's weak as hell. Let's see if this man can be y'all next me. And left it at that. And disappeared for a year like J. Cole did. Now the game wants J. Cole back. Where's your Iceman album? Oh, you mad at the response you got? Drake, here's the thing. You know what you have to do. You just don't want to do it. You got to get back and rap and diss Kendrick Lamar. You just don't know what angle you should take because you thought that this was going to help you. See, the judge took their sweet ass time, their long ass time to do all of this crap. Why? Because we already know you're about to appeal it. But you're going to take another loss there. Drake, get back to rapping, get back to singing, get back to finding new artists, helping them out, hop on new styles, hop on new songs, and continue your reign. You're not done, but you will be if you continue this bullshit. Y'all, let me know y'all thoughts on this one, man. Sure to keep your people aware. We are 38K away from that giveaway of these two things, man. So go ahead and hit that like button like you like something, and I'll catch y'all on the next one. Click right here to see what Derrick Rose told the damn judge about Rice Street, basically. I guess nigga didn't want to be there because he said something wild to the judge today. Threw me smooth the hell off. Click right here, click right here. And if you just want the videos to play, hit that playlist right there, okay? I'll catch you on the next one.